Hello, everybody, and welcome to this edition of Macro Pro and Friends. It is the first of our summer school series, and today I am joined by Emma Nelson. Emma Munson, too, right? You got a hyphenated name.
Yes.
Yes, so thank you so much for being our first speaker. We got a lot of interest in your topic, which is creative settlement strategies. I think everybody wants to know about those. So, since this is our very first webinar for the summer school series, I'm wondering, do you have a summer school series, Emma? I mean, a summer school
Um,
story?
uh, Personally, I did not get to attend summer school growing up. I was a latchkey kid of the 90s. Long stints of biking around the neighborhood, interrupted by a few summer sports and the occasional summer camp. I am hoping summer school becomes a thing. I have a toddler right now, and thank goodness daycare is year round, but that is not going to last forever. So here's
No,
to hoping.
okay, well, I do have my fingers crossed for you. I can say that I did go to summer school in elementary school because that's where all my friends were. So every kid in the neighborhood would go there and, do what we had to do just so we can all visit with one another. As for those of you who know me, you know I am somewhat of a social butterfly and love to do that. All right, so I'm going to do a little housekeeping. We're going to turn this over to Emma. And by the way, my name is Diane Cohen. I am the Vice President and Dean of Education for MacroPro, and it is our pleasure to put these webinars on for you. So today's class is worth 1 CEU credit. You must be logged on to the link that was sent to you. If you were forwarded a link, the person that sent that to you will get 2 certificates, and one will not be in your name. So make sure that you use your own link for that. So you should see that certificate in about 1 hour. Now, if you don't receive that, I can help you in 30 days, but that's it. After 30 days, I cannot help you with your certificate. So make sure you ask me about that in advance. We have handouts available to you in the control console. We have 2 of them. One is from today's program, and the second one is going to be on the summer school series and all the other classes. Not too sure what happened to my camera, but I got really gigantic in it. So then if you have any questions, you can ask those questions in the question box, and I will ask those to Emma. If we didn't get to your questions, I will get those questions to her so she can email you back with that answer. And then lastly, if you'd like to see this or any other program, you may do so by going to the Macro Pro YouTube channel. All right, Emma, I think that's everything. The floor is yours.
All right. Thank you so much. Good morning, everyone. We're here to do our creative settlements discussion, talking about what options are available to us in terms of settlements and workers' compensation, as well as what we can do to um, be creative in affecting those settlements and our considerations and everything that goes into that. So, I want to talk about the pros and cons of trial versus settlement. Trials lead to the unknown. There's a lack of certainty. This is an analysis we have to do in every case, whether we should go to trial or settle. Um, we have certainty with a settlement. With 90% of judges, I do not want the fate of my case in their hands. Applicant's attorney and I are much more knowledgeable about a case that we've been litigating versus a judge that comes in at the end. Especially in complicated cases, the judge will miss something. And so when they're doing their uh, findings and award, something is going to get left out. The judge is going to make mistakes in their decision, and applicant's attorney and I, in terms of putting the settlement together, we have a vested interest in getting that settlement right, whereas the judge just wants this off their desk. The system also requires liberal construction in favor of an injured worker. That means if the evidence is equal 50-50, sometimes even less, then the judge is going to go in favor of the injured worker. Reconsideration. If we go to trial, someone filing for reconsideration or removal is always a possibility. This can do damage. It can delay the case. We keep seeing very liberal decisions come down from the WCAB, especially recently, And as defendants, while we may disagree with the decision, we're often just stuck with them. We also want to avoid the grant for study order, which is now referred to as retaining jurisdiction. Um, this is where the board for a long time was just keeping cases in order to study them further. The appeals board said they couldn't, the appellate court said they couldn't do that anymore. So now they say they're retaining jurisdiction. They're supposed to give an explanation as to why, but boilerplate language seems to work for them so far. And once that happens in your case, it's unclear when you're going to get it back. We also want to avoid making bad law, which is always a possibility when something is appealed. We also want to save money. You will always save money in settling versus your worst case scenario and going to trial, no matter what. Because if you go to trial and your worst case scenario happens, then you have to pay for that, plus litigation costs and potentially the costs along with reconsideration and appeals. And even if you settled at the same amount of your worst case scenario, you've saved the money of trial. Additionally, there's no interest for timely payment of settlements if you've got a lot of disputed benefits, temporary disability, permanent disability, and a lot of time has passed since those contested benefits have accrued. Then if they are awarded following the trial, you may have to pay interest on those benefits. So we want to be closing the cases, and settlement is the best way that we can do that. When to start thinking about settlement. Creativity starts with the settlement timing. We are not just settling at the end of a case or at the MSC or at trial all the time. We want to be considering settlement every time we touch a case. Every time I'm looking at the case, I'm thinking about what is the case value and is it being affected by what I'm doing right now. I want to make sure we have authority on a case. If we don't have authority, why is there no authority? Is it an issue of not being able to value permanent disability? Are we waiting on something? I want to consider why would it be advantageous to the injured worker to settle now to see if there are any issues I need to point out to the injured worker or their attorney to maybe entice them to settle, and make sure the applicant's attorney is aware of that. You can't assume that applicants' attorneys know anything. Even if you think it's really clear, it may not be on their table, they may not be looking at it closely. If I'm getting an MMI report or a PR4 discharge from medical care, I want to think about how that is changing the value of the case. Do we need increased authority? Has the value of the case gone up? Do we need to adjust any prior offers, whether up or down? Maybe we made a minimum offer early on in the case and that needs to be increased because now we have impairment. Or maybe we were overvaluing future medical care before, or the doctors decided that certain body parts are no longer, or certain body parts aren't industrial, whereas before it was questionable. We're looking at settlement at any appearance. For a hearing or a deposition, you know that someone is supposed to show up from the other side, so it's a good opportunity, especially if you have an elusive injured worker or an applicant's attorney who's really hard to reach. These appearances are a good time to try to discuss settlement. I always like to reach out in advance, in terms of advance of the deposition or the hearing. This is so that the attorney can speak to the injured worker and the injured worker has time to consider the offer before we have the appearance. Another time to be thinking about settlement is when the applicant moves, whether it's out of state or out of the country, which I've been seeing more of. The defense costs are going to go up. Any medical legal evals that are not telehealth, we're going to have to pay for travel, lodging, expenses so the injured worker can attend those evaluations. And depending on where the injured worker is, that can be very expensive. The injured worker also can treat outside the MPN if there's no MPN where they are, and so that can increase costs when someone is treating outside the MPN. We also lose control of that treatment, just as far as not having them in the MPN. Maybe they're also moving somewhere where treatment is difficult or just inconvenient for them. I know I've seen, recently some injured workers moving to rural locations. And so getting treatment is harder for them. They have to drive a long way, which also increases our mileage costs. So they might be more interested in settling. Um, we want to look at settlement when an authorized surgery or other big medical treatment is either refused or declined by the injured worker, considering that they may be at maximum medical improvement at that point if they don't want to go forward with a surgery that's been recommended and then authorized by UR. The lack of surgery may increase or decrease our settlement value, so we want to look at that. It depends on whether the surgery may increase or decrease permanent disability. So if it's a surgery that by itself is rateable, or maybe it's a surgery that may increase their range of motion, so their impairment that way may go down. And it's also a question in terms of settlement value as to whether that surgery is just being delayed or if it's being refused altogether, as it will affect the future medical care value. Looking at settlement when an additional QME is being requested or we're scheduling an evaluation with the QME. What is the impact of this additional specialty on the case value? Is it just a site QME, so maybe a little extra in future medical care, but not necessarily permanent impairment? Or is it a QME that may add impairment and future medical care? And can we estimate that? Um, is it potentially easier for the applicant to settle instead of going through an additional evaluation, especially if it's a case where the injured worker has moved so they don't have to travel here for that evaluation? Want to look at settlement when we are scheduling a vocational expert evaluation. If you haven't already, let's calculate what 100% permanent and total disability is going to look like. Compare that valuation with our current case valuation and determine if authority needs to be increased. We also need to consider the likelihood of 100% award based on vocational evidence to see how that's affecting our settlement value. We want to be aware of who we're dealing with when we're settling. The psychology of settlement is understand who you are going to be dealing with over the life of the claim, which may change. Attorneys change, injured workers who were not represented may become represented. In workers' compensation, who the applicant attorney is a huge factor in case value. Are we talking about potentially a Southern California applicant's attorney who might be more likely to be interested in early resolution of the case? Is this an attorney who doesn't settle until they incur a depot fee? I've seen that a lot, and they will. This is the situation where you want to send that offer prior to deposition so they've seen it and potentially discussed it with their client. I've also called about an hour and a half before the deposition because we know that that depot prep starts an hour before the deposition. So I give a call just to make sure they're aware of the offer and they can discuss it during prep. Um, but again, if it's a fee, don't put that in your settlement documents. You have to work that out separately. The judge isn't going to want to see that, but it's something that should probably be discussed at the time you're discussing settlement if it's at the deposition. We want to know, is this a litigious applicant's attorney who is going to want multiple specialties? They like to take doctor depositions, whether it's treaters or QMEs. That's important because that's going to drive up your litigation costs and potentially your permanent impairment. Are they going to send their client to doctors who are going to help them get better? Or are they just sending their client to a doctor who is going to drag out temporary disability, or just send them to very expensive treatments? This is something that you want to consider. What is your venue or board? This is very important, and something that needs to be considered very early on in the case. Is this an applicant-friendly board? Are the judges more defense-oriented? Is it a board with judges who are going to push the applicant to settle or bend over backwards to get the applicant what they want? Is it the Oakland board with a very unique stance on MSAs that can make those settlements hard to get approved? As you're looking at this, you also want to see, is it early enough in the case that you should try to change the venue? It's a litigation strategy, but it's also a consideration for settlement, because I've more and more I'm seeing these questions come up, especially in our firm, about which judges and which boards are going to approve which kinds of settlements. If you have a trial judge, what impact is that going to have on your settlement value? Again, is it an applicant-friendly judge, likely to believe anything the applicant says, even if they don't testify well, as you've seen in your deposition? Is it a defense-friendly judge who is not taking any assumptions in favor of the applicant other than they are legally required to? Is it a judge who will actually set you for trial or drag the case out, and continue the conferences again and again? Who's your applicant? Is it a high earner who is losing money by not being at work? Is this someone who their normal wages are higher than the maximum temporary disability rate, because that's someone who likely is interested in getting back to work as soon as possible? Is this someone who is earning the same or more than they would, um, the same or more in temporary disability than they would by working, such as a minimum earner, because they are probably less motivated to go back to work? Do they have multiple prior injuries? When you see that, you want to look at what were those settlement values and those prior injuries, if you can, and when in the process did they settle their case? Is this someone who was willing to settle early on in their case, or only after multiple medical legal evaluations? Is the applicant the breadwinner for the family and they have other financial considerations that are weighing on them that might make them more likely to settle early? Is it near the holidays? Once we get into November and December, you see a lot more settlements and a lot more movement in settlement negotiations than you do at other parts of the year. Does the injured worker have their own health insurance? If so, then they tend to not be as worried about future medical care costs as someone who does not. Who is your med legal? QME, AME? Is it someone who is never going to MMI the injured worker or take 5+ years to do so? We know we don't know who all of those doctors are, but we definitely know who some of them are. So if that's in your case, you need to be considering that in valuing your case, how long it's going to go, what kind of benefits you're going to have to pay. Is it someone who always uses Kite or Alvarez Guzman to inflate WPI? That should be a consideration. Is it a doctor who does good apportionment analysis or not so good? Like, is that apportionment analysis going to hold up at trial in defendant's favor? Your primary treating physician, as mentioned previously, is also important to the value of your case. Is it someone who will MMI an injured worker? Some primary treating physicians never do, and some absolutely do. Is it a doctor who is, again, going to drag out the temporary disability for the full 104 weeks? Or are they going to try and get that person back to work? Are they going to inflate the case value with expensive treatments like FRPs, or referring them for, I don't know, what's my favorite? I think it's probably the paraffin wax hand treatment. So what are they doing? Who's the doctor? How are they affecting your case value? Valuing your case. This is important, but you have to remove yourself. from the equation. You have to be objective. You're reviewing medical reports. You're relying on the evidence and considering the law and the practical effect. Don't make it personal. Medical treatment. What is being recommended for future medical care by the PTP and the QME? Temporary disability. Can the person go back to work? Do they want to? Do they want to fight going back to work? If the doctor does send them back to work, are they just going to get a new primary treating physician? Um, are there, sorry about that, are there disputed periods of temporary disability? Is there an EDD lien? These are all things we want to consider. Permanent disability, what's the rating? If there's no rateable report, can we estimate? Is it something pretty simple? Is there a kite consideration in terms of whether we have, most likely in the situation of bilateral body parts? Alvarez-Guzman, is that being considered? Are these persons' complaints out of proportion with the injury? Non-industrial apportionment, is it likely? Do we have apportionment between multiple dates of injury? Your voucher, will the employer be able to offer permanent modified work? How many vouchers are they entitled to? Death benefits, rare, but it does happen. If death is caused by the injury, do you have heirs? What kind, and who's entitled to what? So these are what we're thinking about when we're considering the 5 workers' compensation benefits. Okay, medical treatment valuation. We've got a lot of things that we're considering here. Doctor visits. Are they just for flare-ups, or are they more regular? Do they have a regular treating physician? Is it pain management? Is it ortho? Those are going to have different costs. Have they been treating regularly, or did they just treat regularly when they were getting temporary disability? Has the treatment fallen off since they reached their 104-week cap? Physical therapy, massage therapy, occupational, chiro, acupuncture, have they reached their cap? Is there any extension of the 24 visit cap for surgery? If there is surgery, what kind? What does that recovery look like? Is it going to be 6 months before they can be MMI? Is it going to be more? Is it going to be less? Injections, medications, can we base the value off of what's been prescribed so far? Medical mileage, we want to look at, as well as whether there's potentially an MSA that's going to be needed. Temporary disability, this is a lot of times what can be the most expensive valuation in a case when you are, especially when you're at the beginning of the case, because you know what 104 weeks is going to be worth. And so you can include that in your valuation and understand that 104 weeks, we all know that goes by really fast in terms of temporary disability. So we want to make sure that we have the wage statement. Do we have maximum earner? Do we have minimum earner? Are we paying benefits within more than 2 years after the benefits were due? And does that affect the rate that we're paying? Any medical reports showing temporary disability exposure? Does it show start and stop dates? Especially when you have unrepresented workers, the judges are very interested in why temporary disability was, I mean, not so much started, but when it was stopped. And so they want the doctor's report that support that. And is the reporting substantial medical evidence to support payment of temporary disability? This is particularly important when there is someone has been returned to work or had modified duties, and all of a sudden their doctor says, "Oh, they're TTD. They can't be working right now." So is there substantial medical evidence to support that change in TD status? 104-week cap, of course, there are exceptions, amputations, severe burns, chronic lung disease. etc. So then we have 240 weeks. Be aware of that. Are we close to a 5-year statute of limitations? Are they going to be able to use 104 weeks, or is that going to run out? It's not going to run out before the 5 years is up. EDD lien, has EDD paid for the injury during the TD period in question? Are they seeking recovery, or are they waiving recovery as differential payments? This is We'll talk about this more, but the considerations for the EDD lien again can be expensive. Are there any overpayments? What's the reason? Was it late receipt of the report? What the judge is going to be looking for is bad action by defendant or bad action by applicant, and that's really going to weigh heavily on whether a credit is allowed. Additionally, how much is the overpayment, and is it going to wipe out a substantial portion of their permanent disability, which is the other factor the judge is going to be looking for with regards as to whether there will be a award of credit. Additionally, is there a petition for credit on file? Case law is kind of mixed as to whether that's necessary, but it never hurts to have it on file. Permanent disability. Okay. We want to know what is going to affect the impairment and therefore the permanent disability value. Being prepared for these different factors allows us to accurately anticipate the case value and hopefully affect a reasonable settlement. One of the factors affecting impairment value is how the body part is being rated. For a shoulder, will the doctor use range of motion, or is the doctor going to use range of motion plus a distal clavicle resection? If so, does it rate under range of motion or as other, which sometimes can affect the impairment value under the PDRS? Is the doctor combining factors that should not be rated together? So is it an incorrect rating? A good example is if the doctor is combining range of motion measurements with strength, which most of the time under the AMA guides shouldn't be done. Is the occupation code up for interpretation? Is it being disputed? Do we have a job description that helps to nail it down? Considering what was the applicant doing at the time of the injury, and was it a one-off activity that wasn't part of their normal job, and is it something that's in their job description that they were doing? I've seen more and more cases going to trial over occupational code because this can have a significant impact on the impairment value. I've seen it be a difference of at least $10,000 just in terms of how the occupational code itself affects just the permanent disability value. Do you have a doctor who's likely to apply Alvarez-Guzman? Factor this into your evaluation. We talked about how some doctors are notorious for using Alvarez, and some are notorious for using it badly. So are they going to support their opinion? Did they support their opinion for why the AMA guides rating is not accurate and why the alternative method more accurately represents the disability? Kite. This is the case that said the combined values chart is not the only option for determining disability. In Kite, they used addition. More recently, the Vigil decision, which is an en banc decision, affirmed Kite as a method for rebutting the CVC. So do you have a QME or a PTP who is going to be able to support their Kite addition? I know there are certain doctors who I know they're just going to say synergy, like a magic word, which is not enough. They need to explain why that adding the body parts is necessary and why there is why the overlap is increasing the impairment. Apportionment, is it a doctor who will provide apportionment or not? There are doctors where apportionment is like pulling teeth. You could have the same kind of injury previously, and that doctor will just stonewall any attempt to find apportionment. Do you have prior injuries to the same body parts to support the apportionment opinion? Can your doctor, if your doctor is saying there's apportionment, can they articulate the reason for the apportionment, the how and the why? How is the prior injury causing additional impairment, and why? And so, is that doctor's opinion going to be substantial medical evidence on any of these issues? Thinking about whether a supplemental report or a deposition of the doctor would fix the problems. Also have to ask if that further discovery is worth it, both in terms of costs and knowing that the doctor could always mess the opinion up further, or applicant's attorney could throw a wrench into the mix, which just makes it more difficult than it was before. Supplemental job displacement benefit. Not a lot you can do when an injured worker is not represented on the SJDB. If there is impairment and no return to work offer with permanent modified job offer within 60 days of receipt of the MMI report, then it's owed. Possible with multiple dates of injury that multiple SJDBs could be owed. Of course, you can argue that only one is due if applicant is returned to work between the dates of injury, but likely that's only going to work if there's an MMI finding before the second date of injury. You can't settle the SJDB. There is a line for it on the CNR, and judges are on the lookout. If you check it off, they will likely have issues with that. A Thomas or Beltran finding can always help, particularly with a denied case. There's often a little pushback on requesting a Thomas Beltran finding. I'm sorry, there's often little pushback, not a little. The judges, I haven't seen, I'm trying to think, much argument at all from the judges when you have a represented worker. The judge may require you to be specific as to what the basis is for the finding. This is good, especially if you're trying for a Thomas or Beltran with an unrepresented worker, just being specific as to what the basis is. If the applicant has an attorney, although the SJDB can't be settled, we can be creative in how we dispose of that issue. At boards with some of the more particular judges, if the attorneys stipulate regarding the SJDB, I've seen the judges allow that. Those stipulations can be worded such as the parties stipulate that the applicant is not entitled to the SJDB, or defendants agree to issue one SJDB within 30 days, or parties stipulate that the applicant is entitled to one SJDB. I've had attorneys question me as to whether a judge would approve that language, but I've never had a judge say they're not going to approve it. Do we have a large exposure claim? If you have the potential for a large exposure claim, recognizing this early is in your best interest. This case will not get cheaper over time. So understanding the value early on will help you to settle cheaper. Depending on who you're dealing with, robust settlement offers that take into account the potential value may help you settle early. You want to keep the following in mind. Stay out of 100% territory if you can. Keep in mind the LaBeouf decision, where if you're unemployable in the open labor market, that is going to potentially be 100% finding. So is this someone who can potentially keep working or wants to keep working? They're unlikely to have a LaBeouf finding, but do you need to be concerned that this injured worker is fine with never working again? Potentially someone who is thinking about retirement anyways. That's kind of where you're in danger in the 100% finding under LaBeouf. The Nunez decision is also something to keep in mind. So under Nunez, vocational apportionment, en banc decision, which is somewhat in defendant's favor. Essentially, the VR experts can't ignore the medical apportionment. They also can't substitute their own vocational apportionment. The board said that doesn't exist. However, if there is an unapportioned body part, the injured worker can still reach 100% on just that body part. So an example would be someone has multiple orthopedic injuries, and so there's apportionment between the dates of injury, but they also have a psych injury on just one of those, and they're 100% for the psych since there's no medical apportionment. If they're 100% for the psych, then that's going to stand. Will apportionment keep you out of 100% permanent disability? And is it going to keep you out of life pension or 70% permanent disability? So the case is Benson, which is requiring apportionment to other dates of injuries. You want to keep that in mind. As we discussed before, under Kite and Vigil, the case can quickly take a moderate PD case into a life pension case. Something that may have been rated in the 30s or 40s could quickly go into the 70s under Kite and Vigil. Surveillance. If you're looking at a case where you're concerned about 70% to 100%, good surveillance is going to be invaluable in that case. What is good surveillance? We want multiple consecutive days, preferably at least 3, and we want them close to or at the time of an evaluation with the doctor who is going to be reviewing that video. That is going to be the most effective. Sometimes you're not going to get it, but especially when we're looking at high PD, I'm going to recommend it every time. Social media, you'd think it would be obvious at this point, but I'm still finding good evidence on social media that is forcing settlements for below the rated permanent disability value, or settling temporary disability for way less than the 104 weeks. So it's not something we should be ignoring. We're considering all settlement options. We've got our 2 main vehicles, which are the stipulated award and the compromise and release. For a stipulated award, this is good when we have an injured worker who is still working for the employer. Applicant likes the employer or vice versa and wants to keep working, especially if this is a job where the same injury is likely to happen again. So someone with a desk job who has a carpal tunnel injury, or maybe it's just a physical job in general and they're likely to get injured again, compromise and release in that situation could have you buying out the future medical care, and the applicant gets injured again and you are back on the hook for the treatment. The stipulation can be with or without future medical care, but you will need medical reporting to support the lack of need for future medical care. Is applicant refusing to settle even if a CNR is a good option? Sometimes you can't reach an agreement, you're too far apart, so forcing settlement via stipulations is the only thing you can do. Of course, you can also revisit the compromise and release after the stipulations. With the stipulations, you have to remember that you're within 5 years of the date of injury. And so if you're settling within 5 years of the date of injury, you potentially have the opportunity for the applicant to file a petition to reopen. So you want to keep that in mind. That's often why when you see settlement valuations from attorneys will include money to settle that. It's not a lot. And if it's someone who is likely to reopen, it's usually cheaper to settle it than to pay for that petition to reopen. Stipulations are also limiting your settled body parts. If there's future medical care, you want to be very specific in your body parts being settled, where in a compromise and release, I might say, left upper extremity. I'm going to be a lot more specific in the stipulations and say left elbow or left wrist. Compromise and release. This is my preferred method of settlement because it means we're shutting down the case as much as we can. So if the applicant's no longer working for the employer or if the carrier is off the risk, this is a great option. We're settling all issues and claims can close their files. So win-win. If the applicant is still working for the employer, if they want to resign, the CNR can still be a good option. Is if the carrier is off the risk, then if the applicant is still working for the same employer, a CNR can be possible. Usually depends on the relationship between claims and the employer, um, as to whether we're going to proceed with that. Does future medical care have a really large value that is preventing a CNR settlement? I've seen that in a few cases where we have permanent disability worth like 25%, but I've got future medical care that's hundreds of thousands of dollars, especially if you have a younger injured worker with a longer life expectancy. That future medical care could be very expensive. Also, maybe there's just too much of a disparity between the parties and the settlement numbers. We're just valuing it too differently. You could potentially do a CNR with open future medical. Advantage here is that you're settling all the legal issues. There's no petition to reopen. You're cutting off temporary disability, um, but you're also not having to pay out a huge future medical award. Claims file does have to remain open to administer medical care. Um, Again, like stipulations, you have the option to settle future medical care in the future after the initial open CNR. MSA CMS issues. I'm sure you've all done a bunch of trainings for this recently, but you have to consider if you have an applicant who's eligible for Medicare or will be applying within 30 months, or are they currently receiving. Um, so they may need an MSA, and depending on the value of the settlement, you may need CMS approval. Certain boards, mainly Oakland, seem to have a fundamentally different view on what CMS requires versus the actual CMS requirements. So settlements involving MSAs and CMS can be problematic. This goes back to the venue issue, like knowing your board and what settlement you're going to be able to get through at which board. When you have an injured worker who is not represented, you're going to have to talk to them about their pros and cons for settlement. This is a nice little graph. Um, you may have to convince them of a settlement and respond to their particular concerns. So what are their pros for a CNR? Again, they control their future medical care. They do get that large lump sum and it's easier to resolve. They don't have to go through any more litigation. They do not get the ability to reopen. Future medical is closed out. And for an early CNR before a QME, it's possible that the judge may issue an OSA. So that's what you want to consider there. Stipulations. They do get future medical care for life. They do have the opportunity to file a petition to reopen within 5 years. And if the applicant likes the employer, wants to go back to work, this is the best settlement for them likely. However, they do, for any permanent disability that's not accrued, they're only going to get biweekly payments. Future medical care is still going to be subject to UR, which a lot of injured workers really don't like. It's also harder to resolve other disputed issues with stipulations. You want to get your offer out there. Put your offer in writing. That is very important. Applicant's attorney is ethically obligated to communicate that offer to their client. It helps for especially the applicant's attorneys who don't have their file together. You want to show the rating when you're making the offer. As noted here, you might want to get applicant's attorney string rating first. It depends on the applicant's attorney, especially maybe you are using a higher occupational code or an occupational code that results in a higher rating than applicant's attorney is, or maybe they made a mistake in the rating. For the injured worker, if they're not represented, they're not going to rate it themselves. So you are going to want to include the rating. You want to be very clear and upfront with them about any deductions, which means credits for temporary disability or permanent disability advances. Despite injured workers getting these checks every 2 weeks, they assume that they're just getting checks and that's not going to be reflected in their final settlement. So when I'm dealing with a pro per, I want to be very clear, and I say it over and over again, honestly, just like I have to do with applicants' attorneys, that this is less PDAs, um, because it never fails that the applicant's attorney would be like, well, you didn't say you were going to take credit for the permanent disability advances. So that's always fun to deal with. Don't offer all your authority. That's pretty self-explanatory. I wouldn't. But you don't want to couch your offer in terms of, well, let me know if you need more money. But if you're open to negotiation, that's something you can say. Uh, Listen to their concerns. Are their concerns something you can address with the pros and cons, and different ways that you can put the settlement together that would address those concerns. You also want to make reasonable offers. If you lowball them, a lot of people will be offended, which really puts a wrench into settlement negotiations. Because once they get offended, they are less open to negotiation and they feel a little bit more retaliatory. So if we can avoid that, it's for the best. And that's why when you make those offers, supporting the basis for those offers helps show why the offer, at least in your eyes, is reasonable. Using information and assistance, especially with a pro per INA, can be really helpful. For unrepresented workers, if you go before a judge, the judge is most likely going to suggest INA unless you're agreed on all issues. They can provide information and assistance. They can't give legal advice to the injured worker, but they do a good job of explaining to the injured worker just what the law states, not telling them what to do, but telling them basically options that they have. We can also contact INA on behalf of the injured worker. Um, if an applicant just seems really unsure, I like to let them know that INA is an option, and just knowing that it's an option can help the injured worker be more comfortable with a settlement, even if they don't speak to INA. And developing a rapport with the information and assistance officer can help with a case, especially if I've got a problematic injured worker. Um, you know, the INA officer, the judge, and I become a team to try and figure out how to get the settlement or the case moving. Um, Settlement tools, we've got a lot of additional tools that we need to always be considering if a settlement is not going the way you want it to, or if there's something holding it up. If you're deadlocked with the applicant's attorney or the injured worker on the case value, in terms of impairment, go to the DEU. You want to make sure your body part and occupational name and code are correct. The DEU is not always right, but they can be really helpful. And the rating can also let you know if something in your medical reporting needs to be fixed. They can state, well, the AMA guide says you can't rate it this way, but if you did rate it this way, this is what the rating would be. And that's helpful just in terms of like the applicant's attorney or the injured worker knowing that it's not you who is giving an incorrect value to the case, that this is what the DEU says the case is worth. I have called the DEU on some ratings that I think are incorrect, and it was actually a very helpful phone call. They just talked to me and say, well, I had to rate it this way because of XYZ, which gave me the information I needed to fix that reporting with the QME. The settlement itself, sometimes you need to put it in terms for the applicant showing what they're going to get in their pocket. All right. So you want to remember to account for permanent disability advances and the applicant's attorney's fees and any credits, and communicating the settlement in terms of a in their pocket amount is helpful. I know some applicants' attorneys do that with their own clients. And so we might round off an amount so that the applicant is getting a round amount. The applicant's attorney's fee might look a little silly, but here you can see the example. Um, you know, instead of maybe a CNR for $4,970 plus 15%, rounding that to 5,000 is a number that the applicant can understand easily, and then they'll see that, assuming we're not taking any additional credits, seeing that number at the bottom of the CNR is what the applicant is getting is reassuring to an injured worker. Um, Especially with pro per applicants, I always want to explain to them how the numbers are going to show up on the compromise and release and say it multiple times, especially if we have ongoing PDAs. Again, they don't always remember that that's going to be subtracted. So just, it doesn't hurt to repeat yourself on that matter, because you don't want um, all of these settlement negotiations to go to waste when the applicant gets the documents and they're like, oh, this isn't the number we talked about, I'm not going to sign it. So trying to head that off by giving the applicant as much information as possible is good. Um, Time limits on offers. This can be helpful, especially if you are trying to get a settlement done before something happens. 2 weeks before a QME eval, I might do it a little bit earlier because that's coming right up against the deadline to cancel the QME evaluation without a fee. But giving a date or a date certain to try and get something done is helpful, just because it puts a little bit of pressure on the injured worker to say yes or no instead of just stalling. Um, you don't have to abide by that time limit, but once you put that time limit out there, you can, if you want, you can say, okay, the offer is gone. Also, just understanding that AAs typically, if they've discussed settlement with their client, the demand is often double what the client's bottom line is. When I'm negotiating and I know the applicant's attorney isn't just giving me a number off the top of his head, which is going to be more, definitely more than uh, twice the bottom line, that's where I'm thinking about where they're going to move in terms of settlement. Um, Other considerations, temporary disability overpayments. It always needs to be on your mind. Credit, whether credit is required, whether it's going to be waived, maybe a portion of it is going to be waived. EDD liens, need to remember that these have a cash value for injured workers. EDD is like an ongoing account for the injured worker, especially if they have not returned to work and they're not going to return to work. Any money that goes back into their EDD account is there for them to use going forward. If they've been off work for a long time and they've depleted that account to zero, there's no money in there. But if we pay back an EDD lien, they will have that money in there. Applicants' attorneys are aware of this, injured workers are not. So that's something to always talk about, because if they feel like their money is going to EDD, they might have a problem with that. But when they know that money then becomes available to them, they might be more agreeable. Always aware, even if you get apportionment in a QME report, is it a good analysis? We talked about the issues with Kite and Elmer's Guzman, but it's our burden to prove up apportionment, and judges are looking for any reason not to give us that apportionment. So you want to make sure it's a good analysis. Also, for a high value compromise and release, you want to consider a structured settlement. Often I see applicants' attorneys recommending them for certain clients where they don't think it's a good idea for their client to get a large lump sum. Um, so that's always something to keep in mind. Just a few ethical considerations. Offers made by a prior claims adjuster should be honored unless there's a really explainable change of circumstances. So maybe surgery was part of future medical care, um, but they had the surgery, so now that's no longer part of that future medical care value. Um, medical treatment, disputed TD, you should have a really articulable basis for changing a prior offer if you're decreasing it. The attorney has an ethical duty to convey any and all written settlement demands to their client. This goes for defendants and applicant's attorney. So if you're not sure, well, we can't really ask them and they won't tell us, making sure the offer you've made is in writing is helpful. Um, this is important because, I mean, as attorneys, we have ethical duties, but the more we're upfront with injured workers and opposing counsel, the more they will give us the benefit of the doubt going forward. So I just want you to keep that in mind, especially when doing negotiations. This is just a few more details on EDD liens. We talked about how it can be advantageous for injured workers to get those liens paid back. But when we are negotiating them, I know that the representatives at the NorCal boards can be very reasonable, but they will try to negotiate with you. I find the more information I have when I first contact them, the better I'm going to do in terms of settling claims in my client's favor. You want to be very careful about which body parts they paid for. I've seen a bunch of EDD payments where they are paying on an accepted claim, but they're paying for a denied body part. So let's say it's an accepted ortho claim, but they're paying for psych, which is denied. So that's something to keep in mind. And whether defendants would have owed TD in the same situation. I had a case recently where EDD is claiming a year of payments, but they only have one report. And they're saying, well, the report says that he can't work for a year. And I said, that's good for 45 days at best. Come back to me with something more reasonable. That and the judge, it's going to be hard for the judge to argue on that. EDD is still a lien claimant and they stand in the shoes of the injured worker. Duplicate payments are a problem. Yes, they are the applicant's responsibility, but often defendants need to negotiate how that will happen in order to get a settlement done. Applicants' attorneys are very bad at negotiating with EDD. They don't know how to do it, and a lot of times EDD does not like them. So I tend to see that the negotiation goes better if I do it. Especially since I have more of a relationship with EDD than the applicant's attorney does. But technically, the applicant should not get a double recovery. Interest, I want to know why was the case denied? Did we have a notice that EDD was paying? Did we send a notice to EDD that we were picking up benefits? These are all really important because depending on who it is, EDD will seek interest. Also, negotiating these liens before your case is done is helpful in reducing those potential interest claims. Getting the settlement approved by the judge. For settlements being e-filed, I like to send a letter explaining all of these factors to the judge, especially anything that's unusual on the settlement documents, anything that might be out of the ordinary. For example, if a QME report rates higher than what a CNR is for, but explaining to the judge that defendants have surveillance showing applicant at his weekly soccer game, which conflicts with the reported limitations and the applicant prefers to settle versus further litigation. I had one of those go through recently with a pro per and the judge didn't even blink an eye. Um, Also, just make sure that liens are outlined in the settlement. We want, and if the liens are being settled, have that stated just so that the judge is aware that we're aware of the liens. Order suspending action, these happen. You want to address them as quickly as possible. Sometimes it's a really easy fix. The judge just wants additional documentation or has a question. Any responses need to be courteous and professional, and copying the injured worker and their attorney. And if it's something where the injured worker or the applicant's attorney needs to say something to the judge, make sure you're helping to coordinate those. All right, that's it. Let me know if there are any questions. Oh, Diane, you're still muted.
All right, sorry about that. I don't see any questions at all for
Okay.
you at this point, just a couple of thank yous. So I do want to thank you, Emma, very much for being here today and starting off our summer school series. We do appreciate it. I do want to let our audience know what's coming up for the rest of this week. We have a jam-packed schedule for our school. So we have a Medi-Cal set-aside on the 18th, and we also have brain fog. And that's kind of an interesting one. Dr. Diaz is going to be speaking to us about that, you know, what it is, why it is, and if there's any treatments. So that's kind of good to know for your workers' comp claim, but also I think gives some of us some peace of mind. Then we have Dr. Heredia that's going to be talking about the pitfalls of telemedicine, psych evaluations, and I imagine that's going to be really, really hard to do on the phone for sure, or on the screen. And then we got cutting edge on orthopedics, so treatments and surgeries. And so that's going to be great. We got a whole slate of doctors for you guys this week, and we are looking forward to it. And then Friday, we're going to round it all out with upper limb prosthetics. So I hope that you join us for one or all of those. All right. Thanks you everybody for joining us. Again, like I said, you can catch this on YouTube if you'd like to see it again. Bye-bye, everyone. Thanks again.
Thank you.
Bye-bye. Mhm. No, there's no